We're at that order of business, signing of enrolled acts. Enrolled Act number 1, Senate.
Senate Enrolled Act Number 1, being Original Senate File 17, Plane Coordinate System Amendments, an act relating to the Plane Coordinate System.
I'm about to sign Senate Enrolled Act number 1, same being Original Senate File 17. I have so signed. Enrolled Act number 2, Senate.
Senate Enrolled Act Number 2, being Original Senate File 15, Acceptance of Retrocession Federal Military Installation, an act relating to Defense Forces and Affairs.
I'm about to sign Senate Enrolled Act number 2, originally being Senate File 15. I have so signed. Senate Enrolled Act number 3.
Senate Enrolled Act Number 3, being Original Senate File 4, Rehiring Retired Firefighters Continued Retirement Benefits, an act relating to firemen pensions.
I'm about to sign Senate Enrolled Act number 3, originally being Senate File number 4. I have so signed. Messages from the House.
From the House of Representatives, February 28, 2024. Message number 186. Mr. President, the Senate File 30, Influencing Jurors and Witnesses Judges Amendment, passed the House on third reading in an amended form. Ayes 59, noes 3. House respectfully asks the Senate to concur by adopting listed amendments. Message number 28, 2024. Message number 185. Mr. President, Senate File 2, Legislative Budget, passed the House on third reading in an amended form. Ayes 53, noes 9. House respectfully asks the Senate to concur by adopting listed amendments. Signed, Katie Talbot, House Chief Clerk.
Thank you, Randy. Reports from standing committees.
February 28, 2024. Mr. President, Committee Number 2, Appropriations, to whom is referred House Bill 67, engrossed. Outdoor Recreation and Tourism Trust Fund Administration 2 respectfully reports same back to the Senate with a recommendation that it do pass. Ayes Senators Anderson, Guru, and Nethercott. Excused Senators Kinski and Salazar. Senator Kinski, Chairman. February 28, 2024, Mr. President, Committee Number 2, Appropriations, to whom is referred House Bill 75, engrossed. Public Property Amendments, respectfully report same back to the Senate with the recommendation that it do pass. Ayes Senators Anderson, Guru, and Nethercott. Excused Senators Kinski and Salazar. Senator Kinski, Chairman. February 28, 2024, Mr. President, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom is referred House Bill 86, Vehicle Lien Amendments, respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Boner, Brennan, Furphy, Kolb, and Pappas. Senator Boner, Chairman.
Thank you, Randy. Do we have some re-referrals? Senator Nethercott. Come on. Oh, sorry. Just kidding. Yeah. Senator Baldwin, if you're ready on message number, get here, 180, requesting concurrence on Senate File 3. I'll have that read in.
Message number 180, referencing Senate File 3, state employee leave, volunteer fire, or volunteer EMS. Signed, Katie Talbot, House Chief Clerk.
Senator Baldwin.
Thank you, Mr. President. I move for concurrence on message number 180 regarding Senate File 3, state employee leave for volunteer fire or volunteer EMS. And Senators, I ask for your aye vote. Essentially, what the other body did was very straightforward. They changed the language in the first catch, in the part of the catch title complying with the rest of the bill, which is simple and it was needed. And the only thing, other thing it is on page 2, line 1, they added training, so it reads service or training. That's the only things they did. The bill's intact, the bill's in good shape, and I would ask for your aye vote.
Thank you. Further discussion? Seeing none. Motion is that the Senate do confer on Senate File 3, message 180, and vote aye. Chief Clerk will please call the roll.
Concurrence request, Senate File number 3, roll call. Anderson? Aye. Aye. Baldwin? Aye. Aye. Barlow? Aye. Aye. Beitman? Aye. Boner? Aye. Bouchard?
Excused.
Excused. Brennan? Aye. Aye. Case? No. No. Cooper? Aye. Aye. Dockstetter? Aye. Ellis? Aye. Aye. French? Aye. Aye. Murphy? Aye. Guru? Aye. Hicks? Aye. Hutchings?
Excused.
Excused. Aye. Aye. Jones? Aye. Kinski?
Excused.
Excused. Kolb? Aye. Landon? Aye. Larson?
Excused.
Excused. McEwen?
Excused.
Excused. Nethercott? Aye. Pappas? Aye. Rothfuss? Aye. Salazar?
Excused.
Excused. Schuler? Aye. Scott? Aye. Steinmetz? Aye. President Driscoll?
Aye.
Aye. Closing vote. Closing. Vote closed. Senate File 3, 24 aye, 1 no, 6 excused.
By your vote, you have concurred on Senate File 3. Senator Landon, if you're ready on message number 186, requesting concurrence on Senate File 30, I will have that read in. Senator Landon.
Thank you, Mr. President. I would move concurrence on message 186 regarding Senate File 30. Oh, I'm sorry.
Message number 186, referencing Senate File 30, influencing jurors and witnesses, judges amendment.
Senator Landon.
My apologies to the
We're
good
good.
reading clerk. Mr. President, I would move concurrence message 186 regarding Senate File 30, influencing jurors and witnesses, judges amendment. And fellow senators, they had a lot of fun with this little bill down on the far side. You'll remember that this is a bill that was simply clarifying that judges are covered under the offense of influencing, intimidating, or impeding jurors, witnesses, and officers in the court. This statutory language already existed, Mr. President, and all we were doing is making sure that people understood that you can't intimidate a judge. The penalty under this statute was 10 years, $5,000 fine, I believe, and it bounced all over the place down at the other end of the hall, and finally, they landed on 5 years instead of a 10-year potential, instead of 10 years as a potential imprisonment. Mr. President, normally that's a 0 to 10 on a criminal offense like this. And it would be very egregious, I think, for that to ever get to a level of 8, 9, 10 years. There's always been discretion there. This 5 years, I think we're good with that. I think the idea was to simply clarify that language. It does it. It drops that imprisonment sentence down to the 5-year level. I think that's okay, fellow senators, and I would ask that you vote in favor of the bill.
Any discussion? Thank you, Senator Landon. The motion is that the Senate do concur on Senate File 30 and vote aye. The Chief Clerk will call the roll.
Concurrence vote, Senate File 30. Roll call, Anderson. Aye. Baldwin. Aye. Barlow. Aye. Beitman. Aye. Boner. Aye. Bouchard. Excused, Brennan. Aye. Case. No. Cooper. Aye. Dockstetter. Aye. Ellis. Aye. French. Aye. Furphy. Aye. Guru. Aye. Hicks. Aye. Hutchings. Excused. Ayed. Aye. Jones. Aye. Kinski. Aye. Cole. Aye. Landon. Aye. Larson. Excuse. McCune. Aye. Nethercott. Aye. Pappas. Aye. Rothfuss. Aye. Salazar. Aye. Schuler. Aye. Scott. Aye. Steinmetz. Aye. Bouchard. Aye. President Driscoll.
Aye.
Aye. Closing vote. Closing. Vote closed. Senate File 30 concurrence, 28 aye, 1 no, 2 excused.
By your vote, you have concurred on Senate File 30. Senator Case, if you're ready on message number 184, requesting concurrence on Senate File 20. I'll have that read in, please.
Message number 184, referencing Senate File 20, electricity rates for costs that do not benefit Wyoming.
Senator Case.
Thank you, Mr. President. I would move message number 184, the concurrence request for Senate File 20, electricity rates for costs that do not benefit Wyoming, and I'd like to ask you to vote no. Mr. President, we talked about this very issue in the committee, and there's a particular place in the bill, it's on the second page, where, and recall, this bill is about the issue of encouraging the commission and putting in law that the Wyoming ratepayers do not want to pay for costs of a utility that don't benefit Wyoming ratepayers. But there was an important place on the second page where we gave the commission a little bit of discretion. There's a may in the bill, which our friends down the hall, they're even tougher than we are, and they wanted to make that a shall. There's a problem with the shall being at that point in the bill. The testimony we had in committee is that may imply a takings, and that could cause really us to lose the whole ball of wax. So what I'd like to do, Mr. President, is have you appoint a fine conference committee, and we'll go down and we'll talk to them about it and try to work out the difference between the may and the shall. It's an important bill. We all want it. We're going to get it through, but we'd like to talk about it. So I'd appreciate a no vote from the Senate on this concurrence request.
Discussion. The motion is the Senate do concur on Senate File 20 and vote no. Chief Clerk, please call the roll.
Concurrence vote, Senate File 20, roll call. Anderson? No. No. Baldwin? No. Barlow? No. Beitman? No. Boner? No. Bouchard? No. Brennan? No. Case? No. Cooper? No. Dockstetter? No. Ellis? No. French? No. Furphy? No. Guru? No. Hicks? No. Hutchings? No. Ide? No. Jones? No. Kinski? No. Cole? No. Landon? No. Larson? Excuse, McCune? No. Nethercott? No. Pappas? No. Rothfuss? No. Salazar? No. Schuler? No. Scott? No. Steinmetz? No. Larson? No. President Driscoll?
No way.
No. Anderson, no to aye. Closing vote. Closing. Vote closed. Senate File 20, 1 aye, 30 no.
Okay, there's a penalty for that. By your vote, you have failed to confer on Senate File 20. The conference committee will be Case Chair, Anderson, and Rothfuss. Senator Hicks, if you're ready on message number 185, requesting conference on Senate File 2, I will have that read in.
Message number 185, referencing Senate File 2, legislative budget.
Senator Hicks.
Mr. President, I move for concurrence on Senate, or message number 185, and would encourage you to vote no. So this deals with the, what we call the feed bill that Senate File number 2 is the legislative budget, and one of the first bills, and this body put an amendment on there that said, you know, Management Council can establish a task force for emergency purposes by 2/3 vote of Management Council. Our friends down the other side decided they wanted Management Council to have complete undiscretionary authority to form task force, to the extent that then they brought in 2 more task force in their amendment. One of them was actually a bill that's actually passed out of here, which is probably something that we would like to see. The other one you've never even heard of, folks. So for that reason, I would encourage you to vote no, and let's go have a little conversations with our friends down on the other end of the building.
Discussion, seeing none. Chief Clerk will call the roll. I better, motion is the Senate do concur on Senate File 2 and vote no. Chief Clerk will call the roll.
Concurrence vote, Senate File 2, roll call. Anderson? No. No. Baldwin? No. Barlow? No. Beitman? No. Boner? No. Bouchard? No. Brennan? No. Case? No. Cooper? No. Dockstetter? No. Ellis? No. French? No. Furphy? No. Guru? No. Hicks?
No.
No. Hutchings? No. Ide? No. Jones? No. Kinski? No. Cole? No. Landon? No. Larson? No. McEwen? No. Nethercott? No. Pappas? No. Rothfuss? No. Salazar? No. Schuler? No. Scott? No. Steinmetz? No. President Driscoll? No. Closing vote? Closing vote closed. Senate File 2, concurrence vote, 31 no.
By your vote, you have failed to concur on Senate File 2. Committee will be Hicks, Chairman, Senator Ellis, and Senator Barlow. This is fun. Okay, is that the end of the concurrences? Okay. Randy, you're clean. Did we have some? Mr. Majority Floor Leader, we're at that order of business. I'm trying to find more and I can't find it. Consideration of bills on general file.
So, Mr. Chairman, let's resolve ourselves into the committee of the whole. We have a little bit of technical difficulty getting those up there. If we could have those read in, there's 3 bills, so we can get prepared. Are they up there yet?
Okay, I need the motion. I'll read the bills for you.
So I move we resolve ourselves into committee of the whole.
All in favor, say aye. Aye. Those opposed, no. You're in the committee of the whole. Please come forward. We have House Bill 31, House Bill 30, and House Bill 148 coming. Senator French, it's your turn.
Committee of the Whole will please come to order. Your next bill is House Bill 31. Will the reading clerk read it in, please?
House Bill 31 engrossed, Peace Officers, Records and Reporting, an act relating to the administration of government, sponsored by the Judiciary Committee.
You've heard the reading of the bill. What's your pleasure? Senator Landon.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with a due pass recommendation on House Bill 31, Peace Officers' Records and Reporting, and for a good look at this, pardon me? Well, he read in 31. So we're going with House Bill 31. That's my understanding, Mr. Chairman. So that is the Peace Officers' Records and Reporting Bill. And for a description of the bill, please.
To clear up the confusion a little bit, we are on 31, that's how the stack was, so that's how I read it in. So 30 was the second one, so.
Mr. President, we are flexible and glad to operate on the fly. So we're good with House Bill 31, and I moved it. Senator Schuler has a good description of the bill, if you'll call on her, please.
Senator Schuler.
Thank you, Mr. Chairman. House Bill 31, we heard this morning, Peace Officers' Records and Reporting. This bill is a result of an Albany County court case that happened this summer where there was a peace officer standings and training force office was finally forced to sue the Albany County Sheriff's Office for the records of an officer who'd been under investigation since January of 2020. Post had previously reported something like 5 cases in the past year prior to this ruling that required subpoenas to access records. The sheriff in that county refused several subpoena efforts from Post to get the personal records in this case because they said there was ambiguity in the statutes that say peace officer records are only available to direct supervisors. By ruling that Post doesn't have the authority, the court opened up the possibility that Post could be sued by any agency that hands over those disciplinary records to Post. So the House, if you take a look at the bill, the House did amend the bill just a little bit to ease some of the discomfort by some of those members of law enforcement. If you look over on page 2, that's where the majority of the meat of the bill comes in, specifically line 5. That portion of the personnel file that is specifically related to a complaint and relevant to any of the qualifications specified in subsection B of this is really what they're looking for. And if you keep going down on that page, line 14, the commission shall request records under this subsection only for purposes of investigating or determining a peace officer's or detention officer's initial certification, continuing certification, suspension, revocation, or termination. And then at the bottom of that page, we did have quite a bit of discussion on the fact that the personnel file that is received by the Post Commission shall not be disclosed by the commission to any other person except as otherwise required by law. We did have quite a bit of discussion. We had some folks from law enforcement that testified on this bill. I think the biggest thing that you need to understand, I think, with this bill is that it fixes the ambiguity in the statute and it allows Post to access these records. It doesn't broaden investigative powers, and it simply continues a process that's been happening since the 1970s. I know that the Post, the chairman of the Post, gave a few points of data that I thought were interesting. In the last 4 years, they'd had 62 complaints. 6% of them were by other law enforcement agencies other than the parent agency, 13% by the parent agency, and then 19% by citizens. And I think what was important is he said we'll accept complaints from anyone about, possible issues with our officers, but if it's not a serious complaint that falls into the statutes and falls into what might happen with this bill, sometimes he just has the discretion to decide how far those complaints go. So the bottom line, I think, is that Post, eventually they have to answer to the AG, they answer to the commission that votes on certification actions, and additionally, decertification actions are subject to the Office of Administrative Hearings. So that adds another level of scrutiny. So the idea that this bill can turn into a witch hunt is just not true. I think it's a good bill, and I hope you'll support it. Thank you.
Further questions or comment? Senator Rothfuss.
Thank you, Mr. Chairman. I think this is a good bill, but I do have a question about the House amendment about information that is specifically related to a complaint. Who gets to make that determination? I would certainly feel more comfortable if there were in-camera review of a judge or something along those lines for relevant information, but I think of the specific case in this circumstance where there was resistance to disclosure by the Sheriff's Department at that point in time of prior records that were probably relevant in the eyes of an investigation, whether that's Post or anyone else, but may not be deemed relevant by the Sheriff's Department. So I guess I'm curious how that would be carried out. Any knowledge about that in the testimony today? I know that this was an amendment that was added to it, but the amendment is one that I struggle with in terms of how that would actually be implemented. Thank you, Mr. Chairman.
Further questions or comments? Senator Landon.
Mr. Chairman, thank you. And, you know, we did touch on that with testimony in the committee. Keep in mind that as these complaints come forward, the director of Post indicated to us that those are taken under consideration by himself, and then it would go on up through the process, through a commission and on to the Attorney General. Each of these is pretty well vetted, and that ended up giving me quite a bit more comfort, frankly. He indicated that only about 56% of these complaints of any kind that roll in, and they can come from an average citizen, they can come from a law enforcement group, et cetera. Only about 56% of them, Mr. Chairman, are, ever considered and taken forward in any way. So a lot of discretion on the part of the director of Post. And I hope that at least partially answers the question. If not, I'd be glad to chase that down and get back to everyone on second read.
Further questions or comments, Senator Rothfuss?
Thank you, Mr. Chairman. And yeah, I think I'd like a little more digging on that because the language that I'm looking at in context is, it's not just that the personnel file has to be related to a specific complaint, it's the portion of a personnel file that is specifically related to a complaint. It makes me wonder who makes that determination, because Post would not have the full personnel file to make that ruling. The AG would not have that. And the concern has been seemingly that the sheriff's offices or the police offices have been withholding information that might be necessary for an investigation of Post. And if they're the entity that then determines, all right, well, this is the information that we believe is relevant, it's the grading your own homework problem that I think we have there. And I don't know if that language that they put on in the House quite gets at an objective intent here. Where again, I think this is a great bill. I think the intent is good, but I'm just struggling with if that language quite works as intended.
Any other questions or comments? Question being called. Already. All those in favor of Senator Landon's motion that when the committee of the whole rises to report, that it do so with favorable recommendation of House Bill 31, please say aye. Aye. Opposed? No. House Bill 31 has passed. Now we're on 30. House Bill 30, would the reading clerk please read it in? Thank you.
House Bill 30, Controlled Substances Act Possession Amendment, sponsored by the Judiciary Committee, an act relating to controlled substances.
You've heard the reading of the bill. What's your pleasure? Senator Landon.
Mr. Chairman, I would move that when the committee of the whole rises to report, it do so with a due pass recommendation on House Bill 30, Controlled Substances Act, Possession Amendments. Mr. Chairman, I rise with a little bit of trepidation. Me explaining a bill about controlled substances is kind of akin to me trying to dunk a basketball, but So with apologies, I did write down some things so that I can run you through a bill that can be a little complicated. It's an area of our laws that we have struggled with through the years, but this comes from our Department of Criminal Investigation, which during the interim brought some concerns that the crime lab here in Wyoming has encountered with Wyoming Statute 35-7-1031. That particular statute includes the criminal offenses for possession, manufacture, delivery, and possession with the intent to manufacture or deliver controlled substances. Section 1031 distinguishes violations of the Controlled Substances Act based on the schedule of the controlled substance, the form of the controlled substance, the type of the substance, and the weight of that substance, Mr. Chairman. Specifically with regard to form of the controlled substance, the statute distinguishes violation based on whether the controlled substance is in plant form, liquid form, powder or crystalline form, pill or capsule form, cocaine-based, crack form, or LSD. There are various methods and forms of ingesting and using these controlled substances, and sometimes the form in which those controlled substances is in does not fit into one of these categories. As a result, these forms cause problems for the state crime lab in classifying the substance under one of these categories, and ultimately can cause issues for prosecuting any of these drug offenses. So, for example, there are some differences in opinion among prosecutors about how to classify black tar heroin. Additionally, law enforcement has seen an increase in various food products infused with controlled substances, i.e. the edibles. Because of the carrier, this could result in dispute as to what form the actual controlled substance should be prosecuted under. This bill simply removes the consideration of forms. Rather, the amendments determine whether a specific weight is a felony or a misdemeanor by looking to the type of substance, for example, methamphetamine, fentanyl, narcotic, non-narcotic, etc. It also looks to the specific schedule the controlled substance is included in, Schedule 1, 2, 3, etc. That is levels of crime, as you know, Mr. Chairman. The proposed amendments generally, the amendments in this bill generally keep the penalties for these offenses relatively similar to what they were in the past, meaning that the amendment doesn't change much from what was a felony versus what is a misdemeanor. Below is, I'm gonna stop here pretty soon and try to answer any questions, Mr. Chairman, but that's what the bill does. It simply moves some things into the statutes at the request of our crime lab and puts everything on an equal footing. Now, I will submit to you that we can get into a pretty lengthy conversation about whether or not the weights are correct, whether or not, if you take one of these controlled substances in edible form, for example, Mr. Chairman, and then you put it in a glass of water, does that take it from a misdemeanor to a felony? What if you happen to bake some food in a great big pan? Doesn't take very long before you have 3 ounces of that product. We had quite a bit of conversation in committee, Mr. Chairman, about the level of the THC in those products. Once you do that, that would be analyzed, and it probably wouldn't reach that benchmark of that 0.3%. So could it? I mean, absolutely. I don't know that we have these statutes absolutely tied down. Not sure that if you could ever get there with as much as this world is changing with respect to controlled substances. But I do think that the bill is a good one. It was worked by your Joint Judiciary Committee throughout the interim. We took a lot of testimony on it, and it brings our statutes up to the times regarding levels of what we consider legal and illegal and Misdemeanor and felony, we don't change any of that. Is there work ahead? Probably, but that's on a different topic for a different day, Mr. Chairman. I would ask for your support of House Bill 30.
Senator Nethercott.
Thank you, Mr. Chairman. I know that the crime lab has struggled for years and the state has struggled for years on this topic. And one of the reasons why it wasn't solved was because of my previous role here. Because I don't think that this is actually the policy statement that the body wants to make or understands what it is making right now with this bill. If the bill is not ready for prime time, or there's still things that need to be worked, what does that mean in relationship to this bill? It means somebody goes to prison. It means someone is a felon, they lose their rights, and they go to prison. That's what that means in this case. It's not one that we can readily come back and fix without really causing harm to people. So I do think that the conversation isn't about black tar heroin. I don't think that's a concern. I think the crime lab has been able to analyze that for a long time now and do so effectively and determine weights accordingly. I think what we're really talking about here is edible marijuana. And of course, we're seeing that because the majority of the states in this country have legalized it in some form or fashion, and most notably the states all around Wyoming. Every single state has. So we're seeing a significant amount of that on the streets. And those products, as many of you know, come in a variety of fashions, from suckers to brownies to any kind of consumable product that you can imagine that's edible, you can have THC within it. And so my question is, a pan of brownies or a dozen cookies bought 20 miles away, will that 19-year-old young man who went down in college and come back be a felon in our state because of this law? Because he bought a dozen cookies 20 miles away? Question for the chairman.
Thank you, Mr. Chairman. Yeah, I'm not seeing a fiscal note on this. It looks like there could potentially be, this would be an increased tax possibly on this as well too. So I'm not entirely sure of that, but maybe somebody can answer that for me. Thank you.
Senator Hutchings.
Thank you, Mr. Chair. This may be minor, but on page 2, line 16, it talks about the, actually 14 through 19, that no prescription or practitioner's order for the substances listed above shall be valid unless the prescription is for a drug that has received final approval by the United States Food and Drug Administration. And I'm wondering, do we want to allow the Food and Drug Administration to say that something is now valid because they agree with it? Just a slight question. It could be minor, but I'd like to know the answer. Thank you.
Senator Case.
Well, Mr. Chairman, that is old language. That's existing language right now. So that might be a consideration, but that's not what this bill is about, and that's not the bill title is about. But this is about the different forms that controlled substances come. And I was a no vote in the committee. There was some testimony that because of the bill regarding hemp and trying to set a cap on the amount of THC in hemp, that could be used as a guideline so that, that's sort of a lower level of concentration that would affect this, but I don't see that as being really relevant. What it means is that someone could go to Colorado, go to that big green state to the south of us with all the crazy ideas and go down there and buy edible marijuana. And maybe they consume most of it down there, they have a great time, they go skiing, they spend a lot of money there and support the Colorado economy. Then they come home and they've got one of those little gummies left in their car. Doesn't weigh very much, you know, it's just tiny, 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 but they're being pulled over. And so they want to get rid of that little gummy, and they have a big glass of water. So they throw that one gummy in that glass of water. It's the same gummy, same THC, same all that. Now, because the weight has gone up, they potentially are a felony amount. And I just think that's ridiculous. Now, we were told that this is our existing law quandary now. We've had a couple bills about trying to fix this. As you recall, it kind of comes about from a judge's order that said we don't really have a way to qualify edibles in our law. But it seems to me we've skirted around fixing that part and getting down, and then we've literally talking about the volume and weight of inert materials, not really the concentration of the illegal substance with this bill. And I urge you to vote it down.
Further questions or comments? Senator Bouchard.
Thank you, Mr. Chairman. You know, this is the fourth year of going over this kind of language. And every time I've said, I don't want to put young people in this kind of harm's way. I mean, we're too close to, in my county, we're just too close to the neighboring state. And it really worries me that young people who are maybe haven't thought about the repercussions, we're going to make them felons. So, and on another note, does anybody think about putting minors in this? And see if the parent said it's okay, it's okay?
Senator Rothus.
Thank you, Mr. Chairman. Yeah, parental rights. Mr. Chairman, we have worked this bill over many times in the past decade, and I think I've lost count. It's probably at least 4 times that we've looked at something like this to try and clarify. But, Mr. Chairman, each time, you know, I've raised the same concerns that the good senator from Fremont County raises, which is that if we're going to choose, from a policy standpoint, to clarify the illegality of a substance and then have, whether it's misdemeanor or in many cases, as we see here, felony offenses punishable by multiple years in jail, and we know these get prosecuted, there's no question about it. Folks in my community all the time are doing just that. They're heading down to that state south of us, they're coming back, and it changes their life. We need to be technically accurate when we do it. We can't wave our hands with the science of chemistry and of trying to just say, well, about 3 grams. That makes sense. 3 grams of what? 3 grams of whatever. If it's got THC in it, 3 grams is pretty bad. Or we see here an odd equivalence that I guess I just question where something like this comes from, where you assume that in the Romanet 8, possession of methamphetamine in liquid form, heroin in liquid form, fentanyl in liquid form, or LSD in an amount of less than 0.3 of a gram, all of those are equivalent. And again, those above in a liquid form are unlikely to be pure. So the liquid form, if I add 1 gram of water, I've exceeded it, according to the statute. If I haven't added that gram of water, I could be less than that, because it doesn't talk in any way about concentration, Mr. Chairman. And I'm putting on my little chemical engineer's hat at this point in time and saying concentration matters an awful lot when you're talking about chemicals. That's a big deal. That's sort of like the freshman year of chemical engineering, and maybe even before. It's probably 8th grade, let's be honest. It matters quite a bit. And to just pretend it doesn't matter in statute because it's hard to deal with that is not an appropriate approach to a system of justice, right? The state can't just say it's too hard to reason it this way, and so we're occasionally going to screw things up and send some people to jail, but we don't have the equipment to do a great job, and it'll cost us money to have that kind of equipment, so we'll probably get it right sometimes. That's not a system of justice. And that's not a standard that I would ever want held to any of my family members, any of the students at the university, anyone in any of our communities, where they just weigh something and it turns out it contains some THC, and therefore they become a felon because, as the good senator noted, they had dropped that gummy bear into a glass of water, and so the mass that's there has gone up substantially. So, Mr. Chairman, again, I understand there's a lot of interest in these types of policies. There's a lot of opposition to these types of policies. That policy discussion, I think, is to be set aside from this legislation, where the problem with this legislation is that it doesn't judiciously implement the law in a way that provides protections for our people. And as a result, I can't support this legislation.
Further questions or comments? Senator Nethercott.
Thank you, Mr. Chairman. I just don't want to lose my I'm super tough on crime card, and I love my felonies, which I do. You know, I do have serious reservations, which is why for the last 4 years, this was not an interim topic for the Judiciary Committee, knowing that the technology isn't there yet to determine the accurate weights associated with the substance that we find illegal and harmful to people. And if, you know, I'm not willing to make the possession of a cookie, which would reach a felony amount of over 3 ounces, a felony. I think that we're not equipped to handle that in our criminal justice system and can be harmful on society. I don't know that we as a state are ready to go in the other direction either. And so standing still for a minute, I think, is still where we need to be with this kind of uneasy status quo until we decide how we want to approach these products in this society. Here's another reason why I don't support the bill, is the provision that the senator from Albany County pointed out, which is being in possession of a felony amount of liquid form of fentanyl, which is lethal to anybody with even that amount on them, lethal to law enforcement, lethal to anybody who comes around it. Methamphetamine, LSD, that we've dropped the felony standard associated with it to a random 7 years. That wasn't historically those sentences associated with that felony level of drug possession are higher and allow for a range of sentencing much broader. Because typically when we know that if someone is in possession of liquid form of heroin in a felony amount or fentanyl, there's likely more to their story than they're just a drug addict, and there may need to be a strong level of deterrence associated with that activity. A 7-year sentence with how our Department of Corrections works is somewhat ineffective because of how we calculate good time. You're only going to do 2/3 of your time, actually, and so a 7-year sentence may not be effective for being a drug trafficker. So is it worth the level of investigation and effort to go in to make this a deterrent effort with a 7-year sentence? I think not, and I would argue for a stronger and a longer term than 7 years. So I just don't want to lose my tough on crime card, but this is too broad, encompasses too much as we deal with edible marijuana in our society. And so I just have grave concerns, and I'm a no vote on the bill.
Further questions or comments? Senator Schuler.
Thank you, Mr. Chairman. I was also a no vote on this, and for exactly the reasons that have been mentioned, so I won't spend much time, but I just feel like there's too many loopholes in it. Even the issues with the crime lab and what they can and can't do, and we've debated this back and forth. We tried to work on it as much as we could in the interim. I just never felt like it was ready for prime time. I don't feel like it is yet. It's something that we're probably going to have to get our arms around somewhere along the line and figure out what's fair, what's just, but I don't think it's ready right now, so I'm a no vote. I would urge you to vote against it.
Further questions or comments? Senator Landon.
Well, Mr. Chairman, on that note, with 2 respected members of my committee voting against this bill, I will rise and try to answer some questions. No, I really do appreciate the debate today. This is not easy stuff. I would tell you this, that when we talked with our crime lab this morning, and asked that very question, you know, what happens if you take You know, you take a dose of what you can buy down south and you bring it up here, that's probably about 10 grams, far below a 0.3, you know, which is the level of our law. But then you bake it in a pan of brownies, and the good representative of the crime lab said, you know, that would be tested and it simply would not reach the level. So I think there is some capability in the crime lab to be able to determine some of these alternate products. I would just remind the body that these laws exist now. This bill doesn't change the laws as they exist now. What it changes is the form, and that's because the form is changing every day. These products are numerous and more coming on the market all the time. So we either begin to get a handle on that, or we leave the laws the way they are now, which means that out across our state, there's all different kinds of levels of comfort with those who would prosecute these crimes. I don't think that's a good place to be either, Mr. Chairman. So the effort on the part of the Joint Judiciary Committee was to try to at least get this far, which is, it really doesn't matter what form this is in, it's illegal in Wyoming. We have not legalized this stuff. Some of it, the good senator from Laramie County is exactly right, some of it is absolutely lethal. And whatever form it's in, we ought to make sure that our DAs and our court system knows that we expect that it is illegal, and that's what this bill does. I urge your support of the bill.
Further questions or comments? Senator Larson.
Thank you, Mr. Chairman. I don't know what I'm going to do on this bill. I just am concerned with the 3 ounces on the dry weight of marijuana as being a break of where the felony and the misdemeanor is. That might have been the right amount back when our marijuana was like 2% THC. But we're up in the 20% now or higher. And then you get it into liquid form and you're pushing the 80%. So I don't know what you do on that, but I'm just going to talk on the dry weight. When it was at THC at 2%, 3 ounces would do about 168 joints on a half a gram. 168 joints at 2% THC. If you go to 20% THC, that 3 ounces will do you like 1,680 joints. So is that a small amount that someone should be able to have just for enjoyment, or is that a big amount that maybe they're trying to do something else with? So if we go much further with this, I think I'm going to bring an amendment to lower that. The 3 ounce break, I think, is probably one of the highest throughout the nation. I think it's what I've read. So maybe somebody will correct me, but I think it should be lower if we're going to stay with it.
Mr. President, Senator Drexel.
Mr. Chairman, thank you. This is really a tough one. I'm kind of torn on it, but my reading of it, and I may need correction, is first and second offenses are misdemeanors, and other than the meth end of it, and we're into the hard drugs, we do the felonies, but the other ones, it's kind of a shot across the bow, and I think for my end, I'm kind of leaning more towards going that way. If it's gonna be illegal, it's illegal, and misdemeanors are not the big wreck, and it kind of discourages that behavior. And it appears to me, when you look at the highway bus and what's going on, we're getting craftier and craftier how we encapsulate these drugs and move them across the lines and around. And so I think it's time to make a move. We can lighten it up down the road if we need to, but what about anything's a misdemeanor anymore? I don't see where it's an absolute disaster passing this thing. So thank you.
Senator Nethercott.
Mr. Chairman, thank you. And I think I'd look to the chairman of the committee to identify and make sure that the body understands really what's being changed here and what isn't. We already have third or subsequent offenses in law. And so yes, if you get pulled over and you have a joint with less than 3 ounces of dry marijuana, that's a misdemeanor. It's a ticket. It happens again, same deal. Your third time though, that's a felony, depending on the years, 3 and 5. So that's nothing new in our statutes. And so when you see that language, that's not different. The difference with this bill is the weight. And so how is that edible THC product getting weighted? We're not talking about liquid heroin. We're not talking about fentanyl. We're talking about edible THC products and how they get weighed by the crime lab to determine whether or not it's a misdemeanor level or a felony level. And the challenge is that THC is infused into a consumable product. It's very hard chemically to unpackage that. And so what this bill is trying to address is the ability to include the non-THC weight to determine misdemeanor or felony level. Curious to hear further conversation about that. But that's what this bill is really about.
Further questions or comments? Senator Landon.
Mr. Chairman, thank you. And I apologize if I did not answer all the questions that were raised during the debate today. Be glad to chase down a couple of those. This bill during the interim, we had a lot of conversation about that. And it does not solve the dilemma that was brought up by the senator from Laramie County. You know, that's a tough lift. So I simply go back to the premise of the bill, which is if we don't do anything, we already have laws in place. But it is up to this body to give guidance to those who uphold the law for us in the judiciary branch and in law enforcement. And right now, it's nebulous. A lot of them out across our state don't know which way to go on some of this. So what this would do, in my opinion, is to establish the benchmark that regardless of what form some of these substances are in, Mr. Chairman, we consider them illegal in our state. Now, do we want to continue to do that? I don't know. Just about everybody out around us seems to be going the other way. So the good senator from Devil's Tower is exactly right. We're bearing the brunt of that. You know, that's why our law enforcement and our courts are running into this every day. You know, what do we do with this? How much is this? The crime labs are trying to get up to speed. Maybe they aren't quite up to speed. I'm not sure they're ever going to be able to be honest. Regarding this bill, if you choose to move it forward, I think the Senate is very good about working bills like this. I think there is opportunity to take a look, and I'd be happy to work with anyone on some amendments. And I would encourage you to do that. If in the end we don't quite get there with something, it's easy to park it and try some other way, some other time. But today, this is the work of the interim committee, and it at least accomplishes a step in the direction to help our law enforcement. Thank you, Mr. President.
This is an important subject, so we can go on for a little more if you want, or we can call for the question. Question being called. All those in favor of Senator Landon's motion that when the committee of the whole rises to report, that it do so with favorable recommendation of House Bill 30, say aye. Aye. Those opposed, no? No. Those in favor, please stand for a count. Those opposed, please stand. House Bill 30 has failed. The vote was, roll call vote.
Give them the standing division.
Okay. House Bill 30, having failed the roll, House Bill 30 having failed the standing division.
Give them the count.
Ayes 13, noes 15. A roll call is required. Roll call vote, please.
Committee of the Whole roll call vote on House Bill 30. Anderson? Aye. Baldwin? No. Barlow? No. Beitman? No. Boner? Aye. Bouchard? No. Brennan? No. Case? No. Cooper? Aye. Dockstetter? Aye. Ellis? Aye. French?
No.
No. Furphy? Aye. Guru? No. Hicks? Aye. Hutchings? Aye. Ide? No. Jones? No. Kinsky? Aye. Kolb? No. Landon? Aye. Larson? No. McEwen? No. Nethercott? No. Pappas? No. Rothfuss? No. Salazar? No. Schuler? No. Scott? Aye. Steinmetz? Aye. President Driscoll? Aye. Closing vote? Closing vote closed. House Bill 30, 13 ayes, 18 noes.
I'll get this someday. House Bill 30 has failed by a vote of 13 aye, 18 no. I give House Bill 30 having failed a roll call vote pursuant to Senate Rule 65A is deemed indefinitely postponed. The next bill for your consideration is House Bill 148. Please read it in.
House Bill 148 engrossed, regulation of surgical abortions, sponsored by Representative Lawley, an act relating to public health and safety.
Having heard the reading of the bill, what is your pleasure? Senator Baldwin.
bald one. Thank you, Mr. Chairman.
I just forgot the win part.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so as an affirmative motion on House Bill 148, regulation of surgical abortion. There is an amendment, if I can have that read in, please.
House Bill 148, Committee of the Whole Amendment Number 1 to engrossed copy, page 1 above line 1 in.
Thank you, Mr. Chairman. For explanation of the bill and the amendment, we turn to the gentleman on the right side of the room.
Senator Boner.
Thank you, Mr. Chairman. Senators, what we have here is House Bill 148, regulation of surgical abortions. So I'm just going to go over a little bit of background and a description of the bill before going a little bit more detail. So as a reminder, everybody, in June 2022, the U.S. Supreme Court issued a landmark ruling overturning Roe versus Wade in the case of Dobbs versus Jackson's Women's Health Clinic. The court concluded that the U.S. Constitution does not protect the right to an abortion, and therefore each state has the right to decide matters related to abortion in their state. So last session, I'm sure we remember, we passed a law prohibiting abortions in Wyoming with a few exceptions. However, as I'm sure we also know, Wyoming's law prohibiting abortion has been stayed pending the ruling of a district court and a likely appeal to the Wyoming Supreme Court. And as a result, abortion remains legal in Wyoming. So as long as that's the case, we have a responsibility to protect the health and safety of women getting abortions. This bill provides for basic regulations for abortions to protect the health and safety of the public, and it does that in two main ways. First and foremost, it requires that each surgical abortion facility be licensed as an ambulatory surgical center, and also has an ultrasound requirement for chemical abortions. So that being said, we'll go ahead and take a look at the bill. The definitions are ones that are pulled from previous statutes. There's notable exceptions on page 4. We're talking about surgical abortion facilities, so those are new definitions there on page 4. And you'll see, importantly, that we're only counting surgical abortion facilities as if they do more than 3 first trimester surgical abortions in any 1 month, or any 1 second or third trimester in any 1 year. The intent here is to be narrowly focused on the abortion centers that make this as their business model, their focus, and not make an overly broad application. And so it requires that these abortions be performed by doctors licensed in Wyoming, and those doctors have admitting privileges at a hospital within 10 miles of the abortion facility. This is to provide for continuity of care in case of a botched abortion, and it's necessary to address any unexpected medical issues in a timely and effective manner. This bill requires reporting of surgical abortions and a statement that the abortions were performed by a doctor licensed in Wyoming. There's various penalties depending on the provisions that may not be adhered to, varying from a misdemeanor fine of up to $1,000 to a felony of not less than 1 year and no more than 14 years in prison for a doctor not licensed in Wyoming performing a surgical abortion. So also an important part of the bill is a requirement for an ultrasound before chemical abortion. It serves 3 important purposes. First, it confirms the viability of the pregnancy. Second, it confirms that the pregnancy is not ectopic. And third, it verifies the gestational age. So also of importance, Mr. Chairman, you'll see that this only takes effect so long as the laws that we passed already have been stayed. So this is a temporary measure, depending on the way the court rules, to provide some basic safety and oversight of these facilities while the courts decide what they're going to do with the laws that we have already passed. You'll see that there's conforming amendments on the bill on page 10, then some findings. Once again, I know this has been a topic of discussion in the courts, but once again verifying that what you could already probably determine by reading the bill and the temporary nature of this bill, that nothing in this act shall be construed to be creating an individual right to an abortion. It's a effective, immediately effective date, and that's the bill. Mr. Chairman, there is a technical correction on the standing, with the Committee of the Whole amendment. I'd like to discuss that at this time, if that's okay. And so, so we'll go on the Committee of the Whole amendment. This simply makes conforming amendments. There was, during the process in the House, they did add the provisions for the chemical abortions, and so this is effectively cleanup. It has no substantive effect. It's making changes to titles and so on. So that's the Committee of the Whole amendment. I'll stand for questions on that.
Further questions? Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I guess I'm just confused about who this is intending to help. The only effect of all of this legislation that I see is really trying to terrorize women that are interested in having abortions and make it very challenging for any doctors to provide those abortions at the risk of potentially violating laws and ending up in prison. So that's my first question. I really want to understand who this is trying to help. How does this help a woman that is making this choice, going to their healthcare provider? What in here is supporting that woman in any way and their healthcare outcomes? The next question that I have relates to the idea of recording all of this information. So it looks like that's a really important part of this, is to record all of the information about every woman that has an abortion, every doctor that gives an abortion, all of the details about that abortion, when they do it, how they do it, why they do it. What are we going to do with that data? And I guess I'd further ask, what other healthcare procedures do we have where we are that intrusive on the privacy rights of an individual, where the government of the state of Wyoming wants to collect the data and feels authorized to intervene to collect the data on when those medical procedures are given under a circumstance where the state isn't even paying for those medical procedures? How is that the state of Wyoming's business in any way? I don't understand how this isn't the biggest of big governments that we could come up with. And Mr. Chairman, I understand that there's an awful lot of folks in this chamber that support the previous legislation that we passed outlawing abortion. We had that debate already. To the extent that it's not illegal right now, and what we have before us is legislation that, rather than making it illegal because that's in the courts, it makes it overwhelmingly intrusive in a way that I can't imagine we would tolerate. For example, if we were talking about, I don't know, vaccination status, ensuring that we report to the state of Wyoming when every individual in this room gets what vaccine they get, which doctor gives it, on what day, or any other medical procedure that we might opt for. So I'd like to hear a little bit more and learn a little bit more about the motivation for the state knowing all those details. And Mr. Chairman, I'll just straight up ask, is this so that we can come back later and punish these doctors and punish these women so that we've got them on a list? Because that's how it reads, candidly. And I don't know an additional motivation. So if not that, which is a little Orwellian, then what? What do we need to know that for? But even more specifically, the probably outside the title addition over in the House of mandatory ultrasounds for chemical abortion purposes. I'm just curious about the need to know all of the details. There was a discussion of, well, this would provide the following information: gestational age, whether it's an ectopic pregnancy, anything else. But providing it to whom? Is that provided to the state also, presumably? Does the state need to know all of these details? It sounds like that's the answer. And I guess I would ask why. If that's not the standard practice of care that the healthcare provider would ask for, why is the state requiring it? And in addition to that, it would be my assumption, but I want clarification, if these are early gestational age chemical abortions, it's my assumption that that would have to be a transvaginal ultrasound. And under that circumstance, are we, the state of Wyoming, mandating by law a transvaginal ultrasound? And I'm going to assume that everybody in this chamber understands how a transvaginal ultrasound operates. And it seems like that's a little beyond what the state of Wyoming should be requiring of a woman through legislation under any circumstance, if it's against their will. Those are my questions. Thank you, Mr. Chairman.
Further questions or comments? Senator Boner.
Okay, well, Mr. Chairman, we do have that committee of the whole amendment I was hoping to dispose of, so if there's no questions on the committee of the whole amendment, it's technical in nature, I'd ask for the question.
All those in favor of Senator Boner's motion to adopt the committee of the whole amendment number 1 to House Bill 148, please say aye. Aye. Opposed? No. That has passed. Back on the bill. Senator Boner.
Thank you, Mr. Chairman. Just to briefly respond, first and foremost, 23 states have laws or policies that regulate abortion. This is not something that's out of the ordinary. This is, once again, I could repeat myself, this is dealing with basic patient safety. Now, I'm not a medical provider. There are those who are, who probably offer more expansive comments, but certainly healthcare is highly regulated in this state and throughout this country. I'm sure there's a multitude of reports that are required, to include currently, the requirement for reporting abortions. So far, there's been no blacklist or anything like that. So I think, that if we're concerned about the black helicopters getting a little bit too close, we can look to what the current status is and recognize that none of that has happened. So that being said, I think that, there's medical providers here that can provide more detailed analysis of just how heavy-handed we are regulatory-wise when it comes to medical care, and we can have that conversation too, I guess.
Senator Scott.
Mr. Chairman, and I rise reluctantly on this issue. Frankly, I was on the other side of the bill that passed last year. I know there's a lot of people that I know and respect that believe very strongly that abortion is wrong. If the church tells them that it's effectively killing an individual. And I respect that point of view. I have a different point of view, in part because my church has a different point of view and believes that the decision is properly in the hands of the mother, consulting with father, consulting with medical providers as she deems appropriate. That's the belief of my church. I view this bill, Mr. Chairman, as an extension of what we did last year. So frankly, I'm going to be compelled to again make the argument that this bill is an intrusion on the freedom of religion, and I will stand with my church and oppose it. And I respect those that disagree with me, but that's the position I feel compelled to take, for the same reasons I explained last year, Mr. Chairman.
Senator Kinski.
Mr. Chairman, thank you. Pro-abortion or anti-abortion, this bill is just good policy. Abortion is an invasive medical procedure. It's extremely dangerous. Once a woman becomes pregnant, that fetus hooks into the vascular system. Done wrong, a woman can bleed out. This says simply, if you're going to be performing these kind of surgeries, you shall have a license as an ambulatory surgery, and your physician shall have admitting privileges at a local hospital. It seems common sense. Common sense. Under the old Roe versus Wade, these were deemed as an undue burden on a right, which was so that these kind of procedures were held to a lesser standard than things like a knee surgery, which was wrong. Since Dobbs, the Supreme Court has backed out of the business of regulating, making these decisions, and it's devolved to us. I think just as a simple public health measure, there's a compelling case to be made for this. But I'll take it just a little bit further. I'm pro-life, ardently so. Years ago, pre-Dobbs, there's a state to the south of us, a border state, that passed a bill very much like this. And it, quite frankly, limited access to abortions because a number of clinics, fly-by-night, marginal operators, couldn't meet the appropriate medical standard. They closed. The Supreme Court then struck that down. Now, since Dobbs, we have the room to bring common sense regulation back to the table, and that will, quite frankly, I hope, drive some of these abortion clinics out of business. That's my hope. Now, there's a lot of my friends that may be inclined to get a little bit confused because they thought we had banned abortion in Wyoming. Well, the fact of the matter is, Wyoming's abortion ban is under a state court-ordered stay of enforcement. The appeals are slowly grinding through the courts. So we have nothing to stop abortion until that is resolved and that bill and our law kicks in again. So this is an intermediate step to try and impose safety and medical regulations on abortion clinics that will hold them to a higher standard of care and, I hope, force many to close their doors. It's for the protection of life, Mr. Chairman. Thank you.
Senator Salazar.
Thank you, Mr. Chairman. I'll make it real simple. As the author of the Prohibiting Chemical Abortions last year that overwhelmingly passed both chambers and was signed by the governor, I fully support this bill, and I hope others will. Thank you.
Senator Brennan.
Thank you, Mr. Chairman. I just want to reiterate from what we heard from the senator in the back of the room that abortions can lead to a lot of complications, and we're just asking for good policy surrounding that.
Senator Rothfuss, and then we'll more likely go to the question.
Thank you, Mr. Chairman. Mr. Chairman, I understand that we want high-quality health care, but we want that under all circumstances. And in fact, we already have that. We have regulations. It turns out, for example, heart surgery. Heart surgery has the possibility of pretty substantial complications. We don't have anything in statute talking about how to conduct heart surgery. There's a good reason for that, Mr. Chairman. It's because we as a legislature don't know anything about conducting heart surgery, and that would make for awkward legislation. So instead, we do that through professional practice. There are no problems right now in the state of Wyoming that this legislation addresses. Zero. Because these are healthcare providers that are medically licensed, they have to be, conducting in proper circumstances, proper medical procedures, with proper equipment, and they're already regulated. This bill is not about that. This bill will change nothing in that. The intent of this bill is to try and do what wasn't done last time because the courts got involved, which is to try and create bureaucratic pressures to prevent abortions from being taken place in Wyoming, because the previous legislation banning it hasn't taken effect yet. That would be at least a genuine argument on behalf of this is that if we couldn't do it through regular legislation, we'll do it through regulation. But Mr. Chairman, I still am looking for that answer on the transvaginal ultrasound. I still want to know if we are going to require any woman that is interested in a chemical abortion to submit to a transvaginal ultrasound against their wishes. I'd like an answer to that. I think that's a fair thing to ask, since that was amended into this legislation in the last chamber, and it's my understanding that there are proponents of this legislation. I want to know if that's what's being required of all of these women, whether that is proper standard of care or not, right? Because again, this legislation is not about proper standard of care. It's not being written by medical doctors. And it's certainly not under the scrutiny of any of our state medical providers or the associations that we entrust with the professional practice of medical care. No, make no mistake about it, Mr. Chairman, this is about legislating in politics. And is that a political decision we're making? Mandatory transvaginal ultrasounds for women that want to use medical abortions.
Further questions or comments? Further comments? All those in favor of Senator Baldwin's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 148, say aye. Aye. Opposed, no. No. The ayes have it. House Bill 148 has passed the committee of the whole. Next up is House Bill 67. Would reading clerk please read it in?
House Bill 67, engrossed, Outdoor Recreation and Tourism Trust Fund Administration 2, sponsored by Representative Newsom, an act relating to state lands.
You've heard the reading of the bill. What's your pleasure? Senator Schuler.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, they do so with a due pass recommendation on Senate file, not Senate file, House Bill 67. And with that, I'm calling myself to try and do justice to this bill. For those of you that don't remember, last year we passed House Bill 74, which created the trust fund and the income source from tourism. This bill, what this bill does, it creates the Wyoming Outdoor Recreation and Tourism Trust Fund governance structure. So the fund was created, $6 million biennium from tourism is in place, and it's going to be contributed every biennium. But without, the governance, that bill would have been kind of like an orphan bill with money in there with no way to get it out. So the governance structure that we worked on during the interim is very similar to the Wyoming Wildlife and Natural Resources Trust Fund. We spent a lot of time with them, and I think they do a pretty good job. And ours isn't exactly like theirs, but pretty darn close. And just to give you a little background too, during the past couple of years, there were ARPA funds out there for outdoor recreation. Unfortunately, they had a very strict guidelines as what they could be used for. They couldn't be used for shooting ranges, archery ranges, fishing access, boat ramps, or equestrian needs, and those kinds of things. With this Tourism Trust Fund, we'll be able to spend money on those kinds of things as well as all kinds of trails, motorized, non-motorized, hiking, biking, so on and so forth. The funds will be used for grants for government entities. Both the tribes can put in, as well as any kind of nonprofit organizations, as long as they have some proposals that go through the process. So the board that was set up, they will receive and evaluate applications for grants, just like the Wyoming Wildlife Trust Fund. And it has to be, anything above $200,000 will have to be approved by the legislature. There'll be a 9-member board, and the expenses that are involved that are setting it up also came out of tourism as well. The thing about HB 67 is it supports business growth, even though it's an economic development tool. A lot of our small towns and communities, they need the outdoor recreation infrastructure to kind of leverage the economic benefits of this growing industry. Right now, as you well know, tourism is the #2 industry in Wyoming, 16,000 jobs, brings in $2.2 billion to Wyoming. And so not only can we attract new businesses, but I think this will also help us to keep some of our young people in the state. So if you want to just take a look at the bill, page 1, we created the statute. 2 has the account board it's created, talks about the 9-member board. There'll be one from each judicial district. They will reflect experiences in both wildlife management, sportsman, tourism. Again, I mentioned motorized and non-motorized recreators, private land ownership. They'll serve 6 years. Then if you get over to page 3, it creates a secretary. They'll meet 4 times a year. They won't be compensated, but they will get per diem. Page 4 kind of details the grant application process, and it just states what the projects, and once they go through that 9-member board, then those projects will also be reviewed by the Select Natural Resources Funding Committee, and then the small projects that are under $200,000 will be approved. And again, the rest of page 4 just talks about the criteria for the grants, the matching funds, and again, we can take in-kind contributions as well as matching funds, as well as grants. Page 5 continues with the evaluation process. It establishes the criteria for the acceptance or the rejection of the gifts. 6 and 7 talks about the board and talks about what they can and can't do. Page 7 talks a little bit about who they have to report to. They'll have to do an annual report. It'll be required to go to the governor, joint appropriations, and the joint travel and select committee. And then again, 7 and 8 pages detail the grant application and the entities that can apply. If you just keep looking through the language, if you get over on page 13, it starts the new language that creates a trust fund income, and that's where the earnings, interest earnings will be deposited, and the goal eventually is hopefully to get 200 million in there. Page 9, there's details about how the funds from the income account can be expended, and again, anything over 200,000 has to have legislative action. Page 17 talks about the funding model. $6 million will be appropriated from the Tourism Reserve and Special Projects account. $4 million of that will be deposited in the corpus. $2 million will go to the income account, and it's a continuous appropriation. And that's pretty much the extent of a bill. It's a 19-page bill, but in a nutshell, what we're doing here is to try to provide lots of benefits for our communities, our residents. I think there's so many things that we can do that we haven't even thought about in terms of outdoor recreation. And also, I know there've been some concerns by some people are saying, well, we're already getting a lot of folks coming in from different states. We can use these funds or monies to plan, to assure that places are not overrun and that they're managed so that the locals will be happy with what we come up with. I think that's pretty much it. I'm happy to stand for questions. If any of you have any, hope you'll support this bill.
Further questions or comments? Senator Ide.
Thank you, Mr. Chairman. I'm on and against this bill. I think here again, we're entangling the government with something better left to the private sector. Uses public money to in an appropriation that doesn't really necessarily have any oversight from the legislature. So I would hope that we would vote this bill down. Thank you.
Senator Jones.
Mr. Chairman, the money has already been appropriated. We already put the money in this fund last year, and we're just working off the interest on it. So it's already in there. We didn't treat this bill very good when it came around here a week or 2 ago, so I'm hoping that we can this time. These are funds available to all of your communities. Every single community represented here can put in a request to do a project with these funds. And our hopes are that they are sprinkled across the entire state. So it is in there. We're just working off the interest. So let's vote yes on this.
Senator Guru.
Thank you, Mr. Chairman. On and 4, I just want to clear up a couple things. As been stated, The monies that this is used for, that have already been appropriated, came from our statewide lodging tax to be put in a fund, to be put in a trust, to raise up to a level so we can spend the interest money to fund projects. And how do we fund them? We fund them from the ground up. Folks in communities can get together and say, we'd like a trail in our community. We heard a lot of testimony in TRW, Mr. Chairman, about how this could help a lot of communities around the state. Economic development coordinators came and spoke to us about how they'd like to access these funds to use to help better themselves and better their tourism economy. And this governance piece that your TRW committee worked on all during the interim was actually laid out, has been laid out in other funds that we've been using already, that have been used successfully, like our large project fund from our natural resource funding account. I'm on that committee and it works remarkably well. And so these funds are done exactly the same way. Just like I also serve on the Select Water Committee. We fund, when you have large projects, they come packaged up in an omnibus water bill that we just passed last week. This would do the same thing. If you look on page 15, any project over 200,000, repeat, any project will come for legislative approval. I repeat, for legislative approval. So you, all of us, will get a chance, Mr. Chairman, to take a look at the projects one by one and decide for ourselves which one. So we have yet another level of oversight. I've also heard talk, Mr. Chairman, about people being concerned that people are left out of this process, small groups. Nothing could be further from the truth. In actuality, any group can work through their local community to forward projects that then that local community, elected officials could sponsor. Once again, another layer of governance. This bill is ready for prime time, Mr. Chairman. This bill has been worked, it's been vetted. Like I say, the money was appropriated long ago. This is the governance piece. It's been worked, and we've used a template that is working in other funds and has been approved by this body. So, Mr. Chairman, I urge you to pass this bill. It's been worked, and I tell you, it's been a remarkable experience, frankly, to see all the groundswell of support from all sorts of groups all over the state. Hunting, sportsman groups are for this bill. Bike enthusiasts, trail enthusiasts, horse enthusiasts. It runs the gambit, actually, and that's why I think the broad base of support for this bill is there. And some of the misinformation that's been spread about this bill just isn't factual. And so it's really been great that we can clear that up. We're glad to answer any more questions that you may have. Thanks, Mr. Chairman.
Further questions or comments? Senator Case.
Thank you very much, Mr. Chairman. Well, I'm kind of a skeptic, actually. I'm a skeptic about the future of the tourism economy for Wyoming. I know that's been a very, very powerful week, and there was some very good food and lots of good liquor and lots of folks in the tourism industry that tell how great it is. But there's dark sides to the tourism industry and the visitor economy, Mr. Chairman. As a segment of our economy, it's got the highest percentage of workers that don't have insurance. My community, you see people that work in the restaurants living in the park, living on the street in their cars. The impacts of overwhelming numbers of visitors on our natural resources are significant and severe. It's hard on wildlife. It's hard on the infrastructure of towns. And it has another dark side, Mr. Chairman. Our towns are evolving. The towns that are most associated with the visitor economy are experiencing a bifurcation of their communities. More of a separation between the haves and the have-nots. Increase in real estate prices. Driving up the beautiful deal and putting the locals kind of out of business. Lots of folks come to work in that economy, but they're not very good jobs for out. Now, I know in some counties like the the flagship economy where these taxes come, Teton County, they do majorly come there. The reason we have a statewide lodging tax is because they couldn't pass a tax on their own. And those tax revenues need to be distributed around the state, but they need to be established to deal with impacts and to help communities cope with influxes of people, to protect natural resources, to carefully think about nurturing projects to keep them from being overused and destroyed. Because the one thing that'll destroy us in your small towns is driving up the real estate prices so you can't live there anymore or your children can't stay there. Taking your experiences in the mountains and filling them with people. There's a dark side. This bill doesn't deal with that dark side. And that bothered me greatly since the beginning. Thank you, Mr. Chairman.
Mr. President.
Thank you, Mr. Chairman. That was a kind of compelling speech. Didn't have anything to do with the bill we're on. It was kind of interesting. If we need a bill to solve it, let's bring another bill to solve these problems we see. What this bill really does, and it can help create a solution to some of those problems. This is a recreation task force, and it actually uses dollars generated from the tourism industry to enhance local communities. And that's really what it does. It's hiking trails, it's backcountry trails, it's a lot of it. Do those bring more people? Yeah, no doubt about it. And as the state grows, we're gonna have more and more people. We're gonna deal with some growing pains. But this actually is yet another tool in the chest. And I watched the arguments here and it's kind of interesting. It's been told over and over again, the money's already there. You vote against this, what you've done is just left a bunch of money stranded. We'll figure out how to deal with it another date, another time. But you've stranded the money if you've done it. You didn't get rid of the program. You didn't get rid of the money. You just got rid of the rules that helped administer it. And I heard the guy from the Spouting Geyser country talk about the programs. And what it really does is it allows us for one time to be able to actually see what those programs are. And it's worked very well in the case of water and other areas, is we actually can see what those programs are. And if you don't like them, you can vote them away. But as far as tourism, whether you like it or not, don't think it matters what happens. Wyoming, it's our #2 industry right now. And it actually does fund a significant part of what we do down here. And it's one of the few funds and areas we have that actually generates more money. Every time we spend $1 on tourism, and I can't quote, someone else might be able to do it better, but I think you're looking at a 7-8 time return on it. I know it's that way where we live. And as far as driving house values up, tourists aren't driving your house values up. Guys moving in here that live here bring them up. They aren't tourists anymore, they're Wyoming residents. And that's what drives your house values up. I live off the tourist industry. I grit my teeth a little, the highways are busy where I live at.
Senator, can you speak into your mic?
Yeah.
I apologize.
And I'm happy when they're gone. I get to spend a good part of the year when they're not around. If I want to get into people, I can drive south of here, north of here, east of here, and west of here. There's people year round. Thank God the guns we got come, leave their money, and go home. And that's something really nice about a tourist, and it's not nice about the ones that come to stay. So I'd encourage you to vote for this. We've heard lots of things that it doesn't deal with, and all those arguments are correct. We can bring more bills to deal with the perceived evils, but let's actually make it where we can administer a program that we've stood up, we've funded, and now we're trying to be able to actually use the program the way it was intended. Please vote yes.
Senator Ide.
Just real quick, I won't waste everybody's time here, but it's still there again. The government's just getting involved in too many. We look like a smorgasbord of agencies here that are running the private sector. And there is, this money did come from the public. That was a tax. And there's also a $50,000 appropriation in this bill for, administrative fees. So let's just be careful about getting, too many agencies down here. Thank you, Mr. Chairman.
Further questions or comments? Senator Schuler.
There we go, now we got the green. Thank you, Mr. Chairman. Yeah, just to hopefully bring it home, again, remember that the $50,000 that was created to help get this thing off the ground was created by taxes. About 85 to 90% of those are paid by tourists. And so honestly, we're using the Tourism Special Accounts Fund to help set this up. It doesn't take money away from the public in Wyoming, except for those that may stay in a hotel or whatever. But for the most part, 90% of this fund, that the lodging tax fund it goes from the pockets of our tourists that are, they're using our highways and staying in our hotels and using our restaurants and that sort of thing. So it is a nice return on investment. The bottom line is this gives every town and every community in Wyoming a chance to put a proposal that might help them be able to get a little bit more of this tourism to flow through their area. We know where most of the tourists go, but I think there's areas in each of our county that have some special places that a lot of people don't even know are there. And if they, don't have the money or the infrastructure to maybe, build a boat ramp at a cool little pond that they have that, people might want to stop and fish at. I can just think of one in my own town that it's called Sulphur Creek Reservoir, and we get people from all over that once they found out that it's a great place to windsurf, there's a whole lot of people that come. I mean, this would be another example of if somebody in my community wanted to put a proposal together to try and encourage more people to come, I can think of all kinds of exciting things that they could do with that. So again, it's paid for by our tourists primarily. It's a good return on investment. These proposals that will come in, they'll be perfectly vetted by a 9-member board and then as well by the select committee as well. And so lots of vetting. We'll see how it goes. But again, when you see what the ARPA funds did and the amount of money that they had, and only 6 out of 70 proposals got funded, this opens it up to everything. I heard testimony from someone who wants to do an archery range in their community, but they don't have the funds to do that. This might be an example of another proposal. There's so many things out there. I think the sky's the limit. And as the good senator from Teton County mentioned, this has been vetted. We passed the bill, we passed the funding, we just needed the governance, and I think we got it right, and I hope you'll all vote for it. Thank you.
Question being called. All those in favor of Senator Schuler's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 67, say aye. Aye. Opposed, nay. House Bill 67 has passed committee of the whole. Next up is House Bill 86. Would the reading clerk please read it in?
House Bill 86, Vehicle Lien Amendments, sponsored by Representative Brown, an act relating to personal property liens.
Having heard the reading of the bill, what's your pleasure? Senator Boner.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a favorable recommendation of House Bill 86. Vehicle lien amendments, the sponsor of the bill is not on the floor, so we'll have Senator Barlow pinch hit for him and see what happens.
Thank you, Mr. Chairman. We're punting downhill now, aren't we? Mr. Chairman, so this bill is, I think, just a clean approach to trying to address a challenge that some of our lending institutions have had in the state of Wyoming. And this has been a collaborative effort with those folks, with other folks who are involved in this. And so what you'll see, it's a very straightforward bill that basically has a notification of 5 days. When a towing company tows a vehicle, they're given a period of time to notify who might, to find out and notify who might have a lien against that vehicle. And what's happened, Mr. Chairman, is that if some, and this happened actually in my own family, I was recounting this story. A vehicle gets towed, it gets set in a lot, and then it starts accruing storage fees and storage fees and storage fees. And some of those vehicles are owned outright, like the one that happened to be in my family, but some of them are held by a lien. Somebody has a loan on that vehicle, and the person gets to the entity gets to a certain point where they've accrued enough debt, if you will, because of these lien, the storage lien and the towing, et cetera, where they say it's worth it just to leave the vehicle. Right now, there's no mechanism to actually have that communication take place so that the lending institution is notified. So, Mr. Chairman, I wasn't prepared to present this bill. I hope I did it some justice, but that's what we're trying to do. Just mandate some communication so that these lien holders aren't left hanging, aren't receiving huge bills based on these storage costs, which they had no knowledge of. And so with that, Mr. Chairman, I'd be glad to stand for questions.
Senator Ellis.
Thank you, Mr. Chairman. I just wanted to let the body know my law firm represents an entity which has an interest in this bill, so I'll be declaring a conflict.
Senator Kolb.
Thank you, Mr. Chairman. This bill was really gone through thoroughly. They had input from all parties, banks, towing companies, and the timelines that are laid out there were amenable to all parties. And I'll reiterate that it's a common problem that in certain loan situations, the lender is not notified until they accrue so much storage fees that it becomes, as explained earlier, not worth it. So this is a method to be fair to the banks, give them notice, and let them make the choices instead of letting it sit there for an unknown amount of time and then they don't really have a choice. So on and for the bill.
Further questions or comments? Looks like you're ready for the question. All those in favor of Senator Boner's motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 86, say aye. Aye. Opposed? House Bill 86 has passed committee of the whole. Next up is House Bill 75. Would the reading clerk please read it? Just a minute. Whoa, just a minute. Majority Floor Leader. Majority Floor Leader.
I heard that. Mr. Chairman, I move the committee of the whole rise and report.
You're fired.
You've heard the motion. All in favor, say aye. Aye. Opposed?
All right. You got more to go. Be careful. Read clerk will read in the committee of the whole report, please.
Mr. President, your committee of the whole, having had under considerations bills on general file, begs leave to report as follows. House Bill 138 do pass. House Bill 70 engrossed do pass. House Bill 9 do pass. House Bill 64 do pass. House Bill 20 do pass amended. House Bill 197 engrossed do pass. House Bill 31 do pass. House Bill 30 failed to pass committee of the whole and was indefinitely postponed. House Bill 148 engrossed do pass amended. House Bill 67 engrossed do pass. House Bill 86 do pass. Senator French, Chairman.
Senator French.
Mr. President, I move for the adoption of the committee of the whole report.
You've heard the motion. All in favor, say aye.
Aye.
Those opposed, no. Motion is passed. We have a few bills to read in, possibly. I think Senator Hicks wanted to. Committee reports.
February 28, 2024, Mr. President, Committee Number 9, Minerals, Business, and Economic Development, to whom is referred House Bill 141, State Land, Oil, and Gas Leases Operator Requirement, respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Cooper, Ellis, and Jones. No, Senators Dockstader and Rothfuss. Senator Dockstader, Chairman. February 28, 2024, Mr. President, Committee Number 9, Minerals, Business, and Economic Development, to whom is referred House Bill 145, Open Banking Amendments, respectfully report same back to the Senate with the recommendation that it do pass. Ayes, Senators Cooper, Dockstader, Ellis, Jones, and Rothfuss. Senator Dockstader, Chairman.
Thank you, Randy. Mr. Majority Floor Leader, that clears the desk. We don't, here he comes, on the way.
Mr. President, I move that the Senate stand adjourned until 10 a.m. Thursday, February 29th.
Any announcements, Mr. Majority Floor Leader? You got any announcements at the start? Okay. Senator Steinmetz.
Thank you, Mr. President. Your committee number 5, Agriculture, State and Public Lands and Water Resources Committee, will meet Thursday, February 29th at 8 a.m. in Capitol Extension Room 6 and online to consider the following bills: House Bill 104, Omnibus Water Bill Planning; House Bill 93, Animal Reimbursement Program Account Amendments; House Bill 43, State Forestry Good Neighbor Positions; House Bill 36, Natural Resource Protection Act; and House Bill 116, Sage Grouse Implementation Notice to Landowners. We also may get another bill referred to us, so we have scheduled an extra meeting time for that evening upon adjournment. And anything that we don't get through will be considered on adjournment on Thursday evening. Thank you, Mr. President.
Senator Baldwin.
Thank you, Mr. President. Just an early heads up for your Labor, Health, and Social Services Committee, the Perfect 10. We'll be meeting at 8 o'clock on Friday morning to hear one bill, Certificate of Need Repeal, House Bill 24. I don't expect it'll take long. We'll be awake anyway.
Senator Biden.
Thank you, Mr. President. Your committee number 3, Revenue, will meet tomorrow, Thursday. Wait, is tomorrow Thursday? Yes, it is. Wow. Tomorrow, Thursday, February 29th, upon noon recess in Capitol Extension Room W6 and online, take up the following 3 bills. House Bill 3, engross property tax exemption for long-term homeowners. House Bill 4, engross property tax refund program. And House Bill 45, engross property tax exemption, residential structures and land.
Senator Case.
Mr. President, not an announcement, but I've learned that our good friend Bill Landon's brother is gravely ill, and that's where Bill is left. And I'm a strong believer in the power of prayer, and let's hope for the best on that one. I'm not sure when we'll see Senator Landon in the next few days.
Let's take a moment of silence before we go into further announcements. Thank you. Let's keep Senator Landon and his brother in our prayers. Senator Schuler.
Thank you, Mr. President. I just wanted to mention that even though your Senate Committee number 6, Teodoro, we do not have any bills to consider tomorrow. So I guess it'll be a sleep-in day for us unless, you can think of something else for us to do. But I would like to just remind everybody that interim, topics are due by Friday. We'd love to have those in, and we will be meeting as a committee, joint committee, next Tuesday at noon. So, thank you.
Senator Cooper.
Mr. Chairman, or Mr. President, in light of our situation with the good chair of Judiciary, absent objection, I'd like to request re-referral of House Bill 125, repeal of gun-free zones to Senate.
Can't do it at this point.
I'm sorry?
We're on adjourned, so we'll have to do it
I'm
first
sorry.
thing tomorrow. So, Senator Hicks.
Yeah, Mr. President, the Republicans will be caucusing at 9:30 in the morning downstairs to review those property tax bills that are still remaining, that are active here in the House. So 9:30, don't have the room yet, but it'll be one of the meeting rooms downstairs to go through those property tax bills in the morning. We're scheduled to gavel in at 10 o'clock.
Further announcements? Seeing none. You've heard the motion. All in favor, say aye. Those opposed, no. Senate will stand adjourned till 10 a.m. Thursday, February 28th.